Hey everybody, I hope you're doing well today and that everybody is staying safe. What we're going to talk about today is Eisenstadt v. Baird, which is the next case in the con law series that I mentioned last time. If you didn't get a chance to see that video related to Griswold v. Connecticut, I'm going to go ahead and drop a link to it for you here so that you can go and watch. I do recommend you take a look at that particular video, as the legal discussion in that case forms the basis of the discussion for today's. It'll just make it a little bit easier. Because today's case, what we're going to talk about is contraception and single people's access to it, as opposed to married people from the last case. So if you like my channel and you enjoy the content that I'm putting out, do me a favor and hit that subscribe button. And if you like this video in particular, do me a big favor, hit that like button until it turns blue. It really does help the algorithm and gets more people in front of the video. So let's go ahead and talk about the facts of Eisenstadt. William Baird was giving a lecture in Boston University in which he was showing unmarried women contraception and giving them contraceptive foam. And to boot, William there was not a doctor, which means that in Massachusetts at the time, he was committing a felony. The law in play made it a felony for non-doctors to provide things like drugs, medicine, instruments, or articles for the prevention of conception. But, and here's the kicker, there was a second element to that particular law, in that it treated married and unmarried people differently. So for married individuals, you could have access to contraception for purposes of preventing disease and pregnancy. If you were unmarried, you could only have it for disease prevention, not pregnancy. I'm sure there were a whole host of very interesting conversations happening at the doctor's offices for that one. In looking to this particular case, the court took the analysis in two kind of parallel running discussions. The first related to the 14th Amendment and the Equal Protection Clause. In that particular clause, the court admits that there's no reason that the states cannot treat different groups of people differently. That's fine. That isn't precluded in your equal protection analysis. But what is precluded is when you treat different people differently on a basis unrelated to the statute, which means that the court had to figure out what that means in terms of what a classification can be. And what they found was that classifications must be reasonable, not arbitrary, and must rest upon some group of difference having a fair and substantial relation to the object of the legislation, so that all persons similarly circumstanced shall be treated alike. Taking this classification in mind, the court had to ask itself whether or not there was a basis for married and unmarried people under this law to be treated differently. And to do that, first they looked at the history of the law, and what they found was not so much. They considered the history of the law, how it was applied, and even what area of the statute books it was put in. And while the law on its face looked to be health-based, the court found it was actually about morality, specifically keeping people from having premarital sex. And what is probably my favorite fact of this case, this particular law was found in the section of the legal code entitled Crimes Against Chastity, Morality, Decency, and Good Order. It's basically the four horsemen of a Saturday night, and I would like to be the rider on the horse of Crimes Against Chastity, if you don't mind. And in looking to that analysis that we discussed earlier, the court found that trying to prevent premarital sex was not a sufficient basis to treat married and unmarried people differently for the purposes of this law. Taking all of this into consideration, the court found that because there was no reasonable basis upon which to rest this difference in treatment, this law was unconstitutional under the Equal Protection Clause itself. Now, the court also took a second tact and looked at it within the context of Griswold and the privacy right that it discussed in the previous case within the context of the marriage relationship. This court said that while, when we talked about Griswold, it was in the context of a marriage relationship and the sanctity of that relationship, we have to recognize that a marriage is not an entity unto itself. A marriage doesn't buy milk. a marriage doesn't go to work. A marriage is made up of two people, and those two people have individual interests and minds and needs. They are not one entity. And as a result, the privacy right that was previously found in that marriage relationship isn't held by the marriage. It's held by the two people within it individually. The court went so far as to say that the right of privacy, if it means anything, it's the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. So at the end of the day, the court looked at this particular law and said it's unconstitutional in two ways. First, it violates equal protection, and second, it violates privacy, and they struck it down. And so that is how single individuals gained access to contraception in the United States. So I hope you enjoyed this particular case, and if you did, reach down in the comments below and let me know why. Until the next time, everybody, I hope you have a good night.